Good evening, everyone. Good evening. Justice Harrison, Jack Byrne, members of the bench and bar, colleagues, students, friends and guests, welcome to Sydney Law School. My name is Fleur Johns and I'm Head of School and Dean here at the Sydney Law School. And it's my great pleasure to welcome you to the 2025 Paul Byrne Memorial Lecture and to introduce our esteemed speaker this evening, the Honourable Justice Ian Harrison. This lecture honours the memory and the work and contributions to the bar and the profession and the community of Paul Byrne, SC, who is well known to some of you. And it's a great honour and privilege to have Paul's son here, Jack, tonight with us. Thank you for joining us. One of the activities of the Paul Byrne Memorial Fund is to support this lecture, but it also supports the work of the Institute of Criminology here at Sydney Law School, which colleagues here can tell you about later. But before I introduce our speaker and hand over for the proceedings this evening, I want to acknowledge that we meet this evening on unceded Gadigal land and to pay my respects to elders past and present and extend that respect to any Aboriginal and Torres Strait Islander people here in the room today, and to express solidarity on my part and the part of the law school for the ongoing struggles for justice of Aboriginal and Torres Strait Islander communities here on Gadi land and around the country. So our speaker this evening, Justice Ian Harrison, is, as you know, Chief Judge at Common Law and Judge of Appeal, a role to which he was appointed in November 2023. But previously, Judge Harrison was appointed to the Supreme Court of New South Wales in February 2007. But his story starts before then, obviously, as all ours do, when he was educated at Normanhurst Boys High School here in Sydney, and interestingly also in Montana in the US, at Bozeman Senior High School. We are delighted and honoured to call Justice Harrison an alumnus of this law school and to welcome him back. Justice Harrison attended this university between the years of 1969 and 1974, earning a Bachelor of Arts in 1971 and a Bachelor of Laws in 1974. His Honour was called to the bar in 1977 and was appointed Senior Counsel in November 1995, which I just learned was on the same day that Paul Byrne took silk as well. Prior to being appointed to the court, the Supreme Court, His Honour served as President of the Australian Bar Association in 2004 and President of the New South Wales Bar Association between 2003 and 2005. As a judge of the Supreme Court, His Honour has had a particular interest in sentencing and the ways in which alternatives to imprisonment can be formulated to meet the interests of justice. So I think we can safely say that the answer to the title of tonight's lecture, Have I Learned Anything About Sentencing?, is yes. And I'm looking forward, as I'm sure you are, to hearing the rest of the answer to that question, what His Honour has learned about sentencing. So without further ado, I will hand over to our esteemed speaker this evening, the Honourable Justice Ian Harrison. Thank you.
Thank you. Thank you especially for the kind invitation to share some thoughts on sentencing with you all this evening. It's a distinct honour to do so on the occasion of one in the annual series of lectures given in memory of Paul Byrne SC. Paul and I were, as you have heard, appointed as senior counsel on the same day in 1995. That group, for better or worse, included Cliff Hoban, who would later become a judge of the court and chief judge at Common Law, Tony Marr in the Court of Appeal, Stephen Rothman in Common Law and Michael Pembroke in Equity. There was also in that group Dick Edmonds, Les Katz and Alan Robinson, who were appointed to the Federal Court, Helen Murrell, who became the ACT Chief Justice via the District Court, and Robert Kellerman, who also joined the District Court. So although I can't say for sure, even though he was more than eminently qualified to be appointed as a judge, I suspect that Paul's singular love of advocacy and the criminal law would have seen him fighting for the rights of accused men and women long into the years that tragically and prematurely eluded him in the end. He was a swashbuckling kind of character at the bar and universally admired and respected. Paul's experience as a criminal law was far superior to mine. Even after more than 50 years in the law and 19 years of that 50 as a judge doing criminal trials, I still have trouble understanding why police insist that what I would simply call a woman has to be described as a female person. Worse still, a dead woman is now invariably, but at least consistently, a deceased female person. And I'm sure Paul could have explained all of this to me if I'd cared to ask him. As was mentioned, I was appointed to the Supreme Court 12 years after Paul and I took silk in February 1977. I did not come from a background in the criminal law. My practice had been more closely associated with medical negligence and challenges to the wills of rich dead relatives. When I took the appointment, however, it was with the knowledge that I would sit as a single judge in criminal trials and as a member of the Court of Criminal Appeal hearing sentence and convictions appeals from the District Court and the Supreme Court. I resisted an invitation from then Chief Justice Spiegelman to transfer from the Common Law Division to the Equity Division because of the considerable fondness I had developed in a short time for criminal trials and criminal appellate work. In the last nearly 19 years on the Supreme Court, I've conducted a considerable number of jury and judge-alone murder trials, although I see from some of the audience here, members of the District Court, that I suspect my trial experience is far exceeded either by them individually and certainly collectively. It would be fair to say that when I started as a judge, I did not know a whole lot about sentencing. However, that did not stop me from incautiously accepting an invitation at the start of my second year on the court to deliver a paper to the National Sentencing Conference at the ANU in February. That speech is on the Supreme Court website and can be read by anyone who may be interested. Having regard to my relative inexperience in sentencing matters, I somewhat audaciously chose to float the idea, purely for discussion purposes, that if sentences in Australia were reduced in length by 50% across the board, it wouldn't make a significant difference to civilised life as we know it. Well, I can say that was a triumph of hope over experience. I re-emphasised that my paper then, in 2008, was intended for discussion purposes only, but it created a firestorm that burned for a long time and has been fanned to the point of reignition occasionally by media interests who wish to revive or create some negative sentiment following one of my sentences, which seems to be quite often. It caused some mild alarm among some of my fellow judges with decades of experience as criminal practitioners and judges among them, who were happy to treat me and my radical, not to say heretical, views as the ramblings of a bleeding heart civil lawyer. Some years later, in 2010, I sat as the most junior of 3 judges in the Court of Criminal Appeal on what was to become the important case of Muldrock. That case became very significant in the history of the Supreme Court following the decision of the High Court allowing Mr. Muldrock's appeal, overturning the Queen and Way, and the subsequent need to resentence a very large number of prisoners in cases involving standard non-parole periods. It's not that aspect of the case I want to emphasise tonight. Muldrock in the CCA was both a Crown appeal pursuant to Section 5 D of the Criminal Appeal Act, and an application by Mr. Muldrock himself for leave to appeal against his sentence. He had pleaded guilty to a charge of having sexual intercourse with a child less than 10 years of age, the maximum penalty for which was 25 years imprisonment, with a standard non-parole period of 15 years. When he was sentenced, Mr. Muldrock asked that another offence of aggravated indecent assault, contrary to section 61 capital M of the Crimes Act, on the same victim be taken into account on sentence. That offence carried a maximum penalty of 10 years with a non-parole period, standard non-parole period of 5 years. Now, Mr. Muldrock's plea of guilty attracted an uncontroversial 25% discount. But this is where it gets interesting, or at least for me. The sentencing judge in the district court imposed a sentence on Mr. Muldrock of 9 years imprisonment, but apparently controversially provided a non-parole period of only 96 days, backdated to commence on the 22nd of April 2009 and to expire on the 28th of July that year, the day on which he was sentenced. He directed as a condition of parole that it was only to be granted on the basis that Mr. Muldrock was to be taken into a treatment facility in Orange, which provided supported living. It had a capacity to compel residents to reside there and to provide programs of rehabilitation for sex offenders. The service it provided differed from the Cubit program in that it offered holistic support in a therapeutic environment to a maximum of 5 residents and was specifically developed for people with an intellectual disability. The service focused on providing sex offenders with specific intervention on a day-to-day basis through staff support. So Mr. Muldrock's sentence was a sentence individually formulated and structured to account for his particular difficult circumstances. On appeal, the Crown submitted that the sentence imposed by the sentencing judge in the district court was manifestly inadequate and that the sentencing judge had made the following errors. First, that he'd given excessive weight to rehabilitation and Mr. Muldrock's disability and inadequate weight to other purposes of sentencing identified in section 3 capital A of the Crime Sentencing Procedure Act in determining the appropriate non-parole period. Secondly, it was said that the trial judge failed properly to consider the relevance of the standard non-parole period of 15 years in determining the appropriate non-parole period, and that, as I hinted before, is the significant issue that attracted most attention and led to all the so-called Muldrock appeals in the courts. Thirdly, it was said he structured the sentence to reflect an erroneous view that he had power to make conditions about parole. And fourthly, that he had failed to identify any basis for a finding of special circumstances, and in particular special circumstances of a kind or character that warranted a non-parole period which represented a less than 3% of the total term. Mr. Muldrock filed an application for leave to appeal against his head sentence, and he submitted that a term of 9 years was, in all the circumstances, excessive. That contention was raised, notwithstanding that on one view, his non-parole period might have been regarded as an extremely generous one. Mr. Muldrock committed the offences when he was 30 years of age. His Honour found that he was significantly intellectually disabled and accordingly concluded that he was not a suitable vehicle for general deterrence. Indeed, one medical report suggested that he was undoubtedly mentally retarded and could barely read or write. Another report concluded that Mr. Muldrock was in the borderline range, only 1 point from mental retardation, and had little control over his acting out behaviour and little comprehension of what constituted criminal behaviour. Now, in the Court of Criminal Appeal, Justice McClellan, the then Chief Judge at Common Law, rejected Mr Muldrock's application for leave to appeal against his sentence. He effectively took the view that the sentencing judge had given excessive emphasis on Mr Muldrock's subjective circumstances, in particular, the evidence relating to his significant intellectual disability. Peter McClellan said, the submission that the sentencing judge placed excessive emphasis on the protection of the community must also be rejected. He said, given the nature of Mr Muldrock's offence committed on a 9-year-old boy and the fact that he had previously committed a similar offence, there was a considerable need for the sentencing judge to be mindful of the requirement to protect the community. And he refused leave to appeal, or he refused, indeed, he refused leave to appeal. One of the other judges on the Court of Appeal, Justice Howie, who will be known to many of you, agreed. The point of my reference to this case, however, is that I also agreed, and to this day I regret having done so. The reason for my regret is reflected in what became the decision of the High Court, which for presently relevant purposes in Muldrock may be encapsulated in the following order that the court made in the course of hearing that appeal. The High Court said, for the reasons that follow, the Court of Criminal Appeal erred by refusing leave to challenge the severity of the sentence. I remind you and myself that was a decision of the Court of Appeal with which I concurred. The High Court went on, it was conceded below that the District Court judge's sentencing discretion had miscarried. This enlivened the Court of Criminal Appeal's power in its discretion to vary the sentence and to impose such sentence as seemed proper. In resentencing the appellant, the Court of Criminal Appeal should have taken, but did not take, sufficient account of the appellant's mental retardation. The appeal should be allowed and the proceedings should be remitted to the Court of Criminal Appeal for that court to resentence the appellant. And that is what occurred. Now, not in justification of my agreement with the decision, but by way of explanation. When the CCA, of which I was a member, heard Mr Muldrock's case, I'd been a judge for almost exactly 3 years. I sat with 2 very experienced judges. In the case of Rod Howie, a judge with an extensive reputation in criminal law. My only questionable claim to fame by then was to have given the controversial speech I referred to at the sentencing conference, with which both Justices McClellan and Howie had expressed significant disagreement and undisguised annoyance. Justice Howie in particular. Now, I have to say I felt considerable unease at the time that a substantially mentally retarded offender such as Mr Muldrock should not be thought to be not just morally, but somehow also legally deserving of a much more sympathetic hearing in the Court of Criminal Appeal, and the beneficiary of an application of divergent or lateral thinking, so as to create a possibly unique, perhaps novel solution, even though potentially at odds with strict application of what was perceived at the time to be the applicable law. I confess I did not have the experience, but more especially the confidence to take such a view in dissent, even though Mr Muldrock's subjective case seemed to me overwhelmingly to favour a different outcome, or at least the outcome chosen by the sentencing judge in the District Court. I have since learned, I hope, that you should trust your instincts when sentencing. They are very often the best place to start and very often the best place to finish. I think it's important to remember that instinctive synthesis is a compound noun. Now, I've referred to Section 3, capital A of the Crime Sentencing Procedure Act. Most of you will know, but by way of quick reminder, that section deals with the purposes of sentencing, which in brief summary are to ensure the offender is adequately punished, to prevent crime by deterring the offender and other persons, a notion I'll come back to protect the community from the offender, to promote the rehabilitation of the offender, to make the offender accountable for his or her actions, to denounce the conduct, and to recognise the harm done to the victim of the crime, and of the community. Section 5, of course, is a provision that makes sure we not sentence an offender to imprisonment unless satisfied, having considered all possible alternatives, that no penalty other than imprisonment is appropriate. Now, I'll return to alternatives to full-time imprisonment later when I talk about my experience sentencing Constable Christian White. Now, in that one provision, Section 3, capital A, is to be found the dominant statutory exhortation to judicial officers on how to go about the task of sentencing an individual for a particular crime. However, even with statutory guidance, sentencing is one of the most notoriously difficult judicial tasks available. It is often said that there is no one correct sentence. That is a sentiment intended to convey the obvious fact that several minds may differ about a particular sentencing outcome and produce several different results. However, provided that House and the King restraints or constraints are adhered to, among others, the instinctive synthesis approach to sentencing means that there is scope for legitimate differences of opinion in any one case. This is perhaps most notably well understood by practitioners who know well that Magistrate A might be more or less likely to give a bond for an intensive correction order than Magistrate B in the same set of circumstances. This is inevitably just the luck of the draw, and we'll all have been on different sides of that equation from time to time. If you'll permit me to reminisce slightly, I remember many years ago as a young barrister appearing for a man on a plea relating to an allegation that he committed an indecent act in a public toilet. I thought I had a fair chance of a reasonable result in the case until the magistrate commenced his remarks on sentence with the words, "Mr. Harrison, I remember the days when gay meant happy." That magistrate, I should say, was terribly fearsome and, for better or worse, is now long dead. I know that for a fact because as a young barrister, I went to his funeral to make sure. In the final analysis, however, genuine error, that is to say, the imposition of a sentence that breaks the rules in some way, is always amenable to the possibility of correction by a higher court. There is in this country, at least in my opinion, a quite remarkable system of judicial supervision of sentences that are arguably wrong. By extension, the sentence that stands at the end of the appellate process is by definition a, not the, correct sentence. The important point is that minds may differ, and the very possibility that there may be such difference is to be applauded and cherished, not reviled or weaponised. As I say, we have in Australia a system of sentencing that is as fair, at least in my research, and intellectually robust as the fairest and most closely scrutinised system of sentencing that exists anywhere in the Western world. My difficulty, and something I want to touch upon this evening, is that I'm concerned that it is neither universally understood nor appreciated in the community. Moreover, I think it is both actively or at least conveniently misunderstood and misrepresented by particular large sections of the media. I'm also of the view that because of this system, I say again, I'm also of the view that because of this attitude, the system is under constant threat of being diminished and depreciated unless attention to the problem is given now. There is, I think, a very normal and natural tendency among all of us, or at least many of us, to care little about sentencing outcomes with which we are not directly concerned. When involved as criminal practitioners or students of the criminal law, we are all genuinely concerned with sentencing outcomes. Beyond that, it's unusual for people to pay much attention. That seems to be the position of most members of society at large. That is unfortunately so, despite the fact that a sentence of imprisonment is close to, if not the most significant event that can happen to any person. It compares unfavourably with death of a relative, divorce, bankruptcy, or loss of a professional credential. Interestingly, it is often closely associated with one or more of these events. It really takes cinematic depictions of prison life, like The Shawshank Redemption or other films, to bring home the predations and excruciating distress associated with institutional loss of liberty. Men and women in the community with no legal training or experience in the criminal law, in my view, do not often understand or appreciate this. I expect many of you have attended or will one day attend a client in the police cells or at Long Bay or Mullawa or Silverwater or Parklea. You may even attend there following your arrest. But how often have you heard the cry that prisoners get it all too easily or that jail is just a joke? Such a visit is likely to alter your views if you have not already had one. I have no doubt that your actual or anecdotal experience will be the same as mine. One day in jail is bad enough. How much more difficult might we expect several months or years or decades to be? There is, therefore, in this mist of societal ignorance or apathy, a fertile audience for the sowing and dissemination of misinformation. One of the things I wish to emphasise is the popular, not to say populist, community view that no sentence is long enough and that the longer the sentence, the better it is for all concerned. Why this attitude is so prevalent, I don't know. I don't know where it's come from or whether it can ever be changed. There's a cognate attitude to prisoners on remand seeking bail as well. The public assumption is that arrest equals guilt, and so why should anyone not remain in jail until his or her trial? This attitude also now sees legislative recognition following on what are relatively recent amendments to the Bail Act, which are sometimes themselves a response to governmental concern that the safety of the community somehow has to be guaranteed, not merely safeguarded. This is really quite silly, and yet this attitude adversely affects the lives of those whose liberty would otherwise be unexceptional until the trial process can take its course. We could learn a lot from the Scandinavians, and I suspect we can learn very little from the North Americans. What we see emerging in our community today, at least in my view, therefore, is the slide into the regrettable situation where the length of sentences has become the currency of the commentariat. When was the last time you ever heard a radio broadcaster or read a newspaper circulating in New South Wales suggesting that a sentence imposed on a particular offender was simply too long? I'm willing to bet that no one has ever heard or read any such thing. Indeed, it's worse than that. I've even heard broadcasters suggest that the imposition of a life sentence, which tells you something about the nature of the crime, is too good for the person concerned. It doesn't take a genius to appreciate what that comment calls forth, something that we in Australia don't want ever to see again. So what is it that fuels these attitudes? Researchers in several jurisdictions have shown that when people are given the opportunity to impose a theoretical sentence based upon an hypothetical, but in fact actual set of circumstances, they almost always proceed to sentence the offender in the example to a no more severe sentence than was given to the actual offender by the judge or magistrate. This suggests at least that a full understanding of the circumstances will include a proper appreciation of the offender's background, motivations, failings, and general subjective case. Conversely, you will no doubt have seen that an offender's subjective circumstances, such as intellectual or social impoverishment, mental illness, drug addiction, or aboriginality, are regularly scoffed at in the papers and pejoratively characterised as the stock in trade of some tricky lawyer attempting to avoid punishment for a client, rather than factors that are critical to the sentencing exercise. So once again, I ask, why are we so harsh and unforgiving? Moreover, and in a contradictory sense, the community in Australia often takes a generally insular and basically ethnocentric view of sentencing. For example, you may recall not so long ago in Indonesia, an Australian couple was sentenced for the murder of a Bali policeman. The woman was sentenced to 4 years imprisonment and the man was sentenced to 8. The public attitude to these sentences here tended generally to be that these people were Australian and had fallen victim to a foreign system of justice, and that as a result, they have been sentenced to far too long for what occurred. Now, why this reversal of attitudes? The answer's not easily found, I suspect. There may have been an element of cultural superiority involved, and that Australians should not have to endure less, in inverted commas, less sophisticated processes and outcomes of countries near the equator. It's timely to observe that the sentence imposed by the Bali court would be considered lenient by local Australian standards, and I'm certain would be pilloried here if a similar sentence were even considered as suitable punishment for the murder of a policeman. So why the call, the consistent call, it seems to me, for longer sentences here at home? I think the answers are many. First, people are led to believe that long sentences are a good idea. A criminal in custody is one less person to worry about, and the longer the sentence, the less worried we need to be. That attitude, of course, changes when the jailed person is your brother or your wife or your child. Unfortunately, censorious attitudes to applications for bail don't often soften, even when the remand prisoner's full story is revealed. Secondly, the public are never told anything else. Biblical notions of equal punishment and retribution have a self-satisfying ring to them. Thirdly, the public never gets the opportunity to distinguish between grades of seriousness of like offences. All murders are murders, all drug sellers are the same, all one-punch assailants are drunks on the lookout for trouble. There's no information of a comparative type that permits rational discrimination between the worst and the rest. Fourthly, it makes those people who escape or avoid the criminal justice system feel better in themselves if other folk are less fortunate. This seems to me to be a species of comforting schadenfreude that people seem to embrace, taking vicarious delight from the suffering of others. Now, is any of this important? If I'm correct in my assessment that sentences have become an important subject of the news cycle, there's little to be said for encouraging sentences that are not newsworthy. Accepting that it may on one view be circular to argue this way, it explains the reason why one never hears news of a sentence being reduced or overturned unless it supports the contention that sentences should be even longer. A prime example of such an instance is the case of Barbieri and the Queen in 2016, in which the sentence imposed on an offender who pleaded guilty to killing a policeman was unexceptionally, in my view, reduced by 10 years on appeal upon the basis that the sentencing judge had in effect given insufficient weight to the effects of his severe mental illness. Once again, that was a case in which populist media reports of the offence emphasised the occupation of the deceased and downgraded the significance of the particular subjective circumstances of the offender. And the court concluded that the offender was, in that case, among other things, an unsuitable vehicle for general deterrence because of his mental illness. A similar public outburst of irrational rage occurred in the case of the sentence of one of two brothers involved in the concealment of a death of a Griffiths schoolteacher. You may recall this, it achieved significant publicity. The brothers, who were twins, were sentenced separately. The brother who committed the actus reus was the second to be sentenced. In the events that occurred, the sentencing judge sentenced that brother ultimately to life imprisonment. However, the other brother was sentenced first for being only an accessory after the fact. He was sentenced to a term of imprisonment that roughly corresponded to his time served, and he was released. The public reaction to that sentence was swift and unfortunately predictable. There was public outrage. If you believe the papers or what you see on the news, large crowds gathered outside the court and it all became very rowdy and unpleasant. It was clearly the result of the public's inability to distinguish between the criminality of the two brothers. The sentence imposed on the accessorial brother was proper and unexceptional, a fact that should have been apparent to those who reported it. The corollary of this tale is that when it became known that the brother who committed the actual killing proposed to appeal against the severity of his life sentence, the media circus started up once again upon the then untested assumption that no lesser sentence could ever be warranted. Now, there's an even more fundamental problem with the public's perception of sentences and the way the media consistently assert that because they are somehow not long enough, they must therefore be legally wrong, meaning likely to be overturned on appeal. This common but self-serving misconception is dangerous and needs to be corrected. Not long ago, I was required to sentence a woman called Harriet Rann, the daughter of a now deceased former premier of this state. I should say that I gave thought to not referring to Ms. Rann by name this evening, but the sad tale is irrevocably linked to her identity, and in any event, the details are now regrettably in the public domain, as I will explain. Ms. Rann was originally charged with murder, along with two accomplices, when a drug buy at a Redfern flat went wrong. Ms. Rann's liability for murder was dependent upon the Crown being able to prove that she knew that one of her co-accused was armed with the knife that ultimately killed the deceased. Ms. Rand denied that she knew this. Significantly, neither of her co-accused was called to give evidence against her at the trial, so that the Crown case on the important aspect of what she knew was deficient. There had been no witnesses apart from the three accused who could have spoken to whether or not Ms. Rand had foreknowledge that her co-accused was armed. The Crown ultimately accepted Ms. Rand's plea of guilty to being an accessory after the fact to murder and robbery in company in full satisfaction of the indictment. I sentenced Ms. Rand to a term of imprisonment of 4 years with a non-parole period of 2 years for the robbery offence and a period of 1 year for the accessory offence. In the events that occurred, Ms. Rand had almost served the non-parole period by the time she was sentenced and was released on parole shortly thereafter. The press reaction, among other issues that are not presently relevant, was to suggest that the sentence was appellably wrong, that she was receiving favourable treatment because of who she was, meaning, of course, who her late father was, and that the Director of Public Prosecutions should immediately appeal. The Director of Public Prosecutions did not immediately appeal. The Director of Public Prosecutions did not appeal at all. Although I perhaps have skin in that game, it seemed to me that that decision not to appeal was entirely unexceptionable, because any informed understanding of the sentences I imposed in the particular circumstances would appreciate that, on one view, they were arguably stern. They were entirely in accordance with the principles in the guideline judgment of Henry. However, it did not suit the media to accept that the total sentence was appropriate. Their only interest was to assert that it was not long enough and ought to be challenged. Now, a particularly cynical corollary of this was that the Daily Telegraph subsequently ran a potentially mischievous article drawing attention to the so-called discrepancy between the sentence imposed by me on Mr. Lee, who committed the act of stabbing that killed the deceased, and the sentence I imposed on Ms. Rand. The inference from what purported to be an interview with Mr. Lee was that Ms. Rand's involvement in, or if you like, her criminal culpability for the death of the deceased was greater than was reflected in the offences to which she pleaded guilty. That was probably intended to be a swipe at me, but I suspect quite unknown by the journalist was in fact a clear and unwarranted collateral attack upon the prosecuting authorities. Significantly, however, the tone of the article was capable of being understood as suggesting that the courts and judges exercise some kind of prosecutorial role and have a say in what charges are brought and what charges are dropped. I need to say no more about that obvious and gratuitous mistake. One predictable byproduct of certain criticisms that I directed at the standard of media reporting of the case before trial were a subsequent series of articles in the Daily Telegraph that were critical of me. I had by now become accustomed to these articles, and there have been many. But the writing of these articles was probably standard for the course and not something that troubles judges, in my experience, in any particular way. One unintended feature of this criticism, however, and a matter that I think particularly galls or galled the sub-editorial and editorial staff at the Daily Telegraph, was that the paper referred to the hopefully academic presentation that I had offered up for discussion at a sentencing conference in Canberra in 2008, in which I posed the theoretical, hypothetical question whether having the current non-parole periods of all currently serving prisoners would have any adverse effect if they were halved and so forth. I realise I've already mentioned this. The newspaper sought entirely unsuccessfully to embarrass me by drawing attention to this paper that had become, I thought, lost in the mists of time. The sweet irony, of course, was that my paper could not have been given better publicity if I'd paid someone to promote it. But without labouring the Rand case too much longer, I suspect the one thing that really annoyed the media was the fact that I accepted submissions from Mr. Bolton of Senior Counsel on behalf of Ms. Rand that the adverse publicity she had received from the newspaper amounted to extra-curial punishment. That is to say that the sentence should take into account in her favour the fact that the publicity was a punishment beyond that which I as a judge could impose. Now, I have perhaps self-indulgently included in this paper a series of paragraphs from my remarks on sentence in which I went to some length to recount the poor treatment that Ms. Rand had received in the series of articles in the paper. They started with headlines such as "How I Ended Up in Hell," and included lengthy extracts from letters sent to Ms. Rand by her co-accused and other private letters published in full online that Ms. Rand had sent to a personal friend. She was described as Dirty Harriet, with the subheadline, "Revealed, Rand's role in Ice Junkie's plot to murder a drug dealer," and so on and so forth. Part of what I said in dealing with these collateral attacks upon her, bear in mind she was by now on parole and struggling with a drug problem. I said, "It is submitted on behalf of Ms. Rand that this publicity has been humiliating for her and has caused her immense psychological distress in her already vulnerable condition. The articles to which I've referred make allegations about her criminality, sexual conduct and reputation that have no basis in fact, but from which she has no ability to defend herself. Ms. Rand maintains that these publications appear designed to invite public vilification and opprobrium, and that some imply she has sought or received special treatment due to her family connections." I won't repeat all of my remarks, but I took into account, again, as I say, ironically so it would seem, as far as the paper was concerned, their gratuitous criticism of her and public attacks in the sentence that I imposed. And if you have nothing better to do, you can read my charge. Anyway, more recently, much more recently, I was called upon to sentence Christian White, a police constable who caused the death of a 95-year-old woman in a nursing home in Cooma, who was suffering from dementia, by employing his taser to disable her when she presented to a staff member holding a knife. Constable White was found guilty by a jury of manslaughter by reason of either criminal negligence or unlawful and dangerous act. Bear in mind that he was legally entitled to use his taser in the course of performing his duties, so the manslaughter charge he faced, not to say the conviction, was not without some controversy. The maximum sentence for manslaughter is 25 years imprisonment. There's obviously no standard non-parole period for obvious reasons. There's also no power of a sentencing court to impose an intensive correction order. And so I ended up sentencing Constable White to a community correction order with a condition attached to that, that he serve a period of 2 years and 425 hours of community service pursuant to Section 8 of the Crime Sentencing Procedure Act. Now, that sentence attracted significant negative attention in some sections of the media. In particular, as you may recall, members of the deceased woman's extended family en masse called publicly for justice, a phrase that arguably failed to give recognition to the fact that Constable White had been convicted for the wrongful death of their mother or grandmother, when on one available view, a jury verdict acquitting him was equally probable on the evidence. In sentencing the offender, I had anticipated the likelihood of some reaction of this type, and I attempted subtly, or some may say unsubtly, to indicate as much in my remarks on sentence, which, if you would again briefly indulge me, I'd like to repeat for your benefit now. There are 3 paragraphs and they're as follows. I said, before I proceed further, it's important to note the following things. It is usual and perfectly understandable that many people will have an interest in the result of any sentencing proceedings and not merely the offender awaiting sentence. People other than those who are directly involved in the events that give rise to the relevant offence, such as an accused, often have and forcefully express a desire to follow what happens in court. These include, as in this case, that case, relatives and friends of the deceased whose position as victims is expressly recognised by statute. Further and more generally, complete strangers to the proceedings, such as members of the general population and the local community, and often in large numbers, although only affected indirectly, nevertheless remain vicariously invested in the due administration of the criminal justice system. These individuals are entitled to a clear explanation of what happens to an accused person or what sentence is imposed and why. These different roles are not necessarily mutually exclusive. Next paragraph. I said sentencing is a complex and complicated task. It is not designed to be so. It is not intended to vex the uninitiated. But unlike theatrical or cinematic representations of this aspect of the criminal law, sentences in this country are not handed down without giving due consideration to a very large number of important and often contradictory themes. I have watched, I said, for many years now, at least some of those assembled in courts to hear counsel submissions on sentence who feel the need audibly to express frustration and dismay that the court's decision is not instantaneous. That is understandable. I said that case proved to be no exception. My final paragraph that I want to read from that judgment was this: the things to which I will now direct attention, I said, are essential matters to be considered and dealt with in these proceedings as in any similar case. It may appear to some to be overly technical, tedious, and pedantic. However, we are in this country the beneficiaries of a remarkable system of criminal justice, something I'd earlier referred to. My task in sentencing Mr. White constitutes a significant example of the operation of that system. And this, I hope, was the crunch line. I said, but while it is acceptable and understandable that opinions about judicial decisions will inevitably differ, it would be a fundamental error for any particular individual or group of individuals to conclude that the worth of our system of criminal justice is coextensive with or is only to be judged by that individual or group's level of agreement or satisfaction with the sentencing outcome in any particular case. These were views that I've consistently attempted to promote in my judgments, history will record that my attempt to communicate these sentiments, particularly to the relatives and friends of the deceased on this occasion, were not apparently successful. The relatives called for, and the Crown agreed to, an appeal against the inadequacy of my sentence. That appeal was unanimously dismissed by the Court of Criminal Appeal. Now, that case was another example of the developing political significance of so-called victims' rights. I wish to emphasise that I'm not critical or dismissive of that development. These so-called rights have in a limited sense become enshrined in legislation in the context of victim impact statements and the expanding use to which sentencing judges are required or permitted to take them into account. Unfortunately, in my experience, the attitudes and level of understanding of victims and victims' representatives tend, perhaps unremarkably, to be significantly one-dimensional and not necessarily much in harmony with the dispassionate and objective mind that a sentencing judge is required to apply. Quite interestingly, I note in passing that in the case of Christopher Dawson, whose case attracted enormous publicity and spawned a podcast, the family of the deceased woman, Lynette Sims, said not one word, to my knowledge, publicly that was critical of the sentence I imposed upon Mr. Dawson for killing his wife. That would appear properly and reasonably to have, they would appear properly and reasonably to have accepted that a non-parole period of 21 years imprisonment for a man in his mid-70s satisfied all of the relevant factors that one needs to consider when imposing a sentence. Curiously, the papers in that case for once appear to have agreed. The issue of detention or imprisonment with, so far as it relates to asylum seekers, is even more perplexing. Clearly enough, people in immigration detention have not committed a crime or been sentenced in the conventional sense, but their practical circumstances are not much different to a remand prisoner. At least a remand prisoner understands the charge that he or she faces and will, with any luck, have a fair idea of when a trial might be expected. The issue with asylum seekers is not whether their indeterminate detention is too short or too long, but whether anyone cares at all. There is no easily understandable relationship between the seriousness of something they are alleged to have done, coming to Australia, and the wisdom of keeping them in custody. The default position of the media, with some notable exceptions of opinion pieces, is that deterrence is at work here. The boats have stopped, so the detention period can last indefinitely. So the burden of all this is that there is alive and well in our community a feeling that accused and convicted people deserve no sympathy and should be put away for as long as possible. This sentiment is the currency of the market that lives off others' suffering. It is non-discriminating. It insidiously undermines the judicial process and confidence in judicial officers who are necessarily exposed to unwanted and unnecessary pressure. Public scrutiny of sentencing decisions is essential. Ill-informed, or far worse, uninformed criticisms are not. The lives of accused individuals should not so easily be called up for barter in the daily news cycle. I think it's essential as practitioners and students of the criminal law that we all hold fast to principle and apply it in the face even of ignorance and prejudice. I was going to say something about deterrence. It's sufficient if I indicate that I am not and haven't for a long time been a fan of general deterrence. But I won't extemporise. Perhaps I should say what I was going to say. If one of the objects of sentencing is to protect the community from the offender, it has to be realised and accepted that there are limits to this protection. Every convicted person cannot be locked away forever. When a person is sentenced, his or her case receives intense scrutiny from all sides in the court. A proper sentence is determined having regard to the available information. Sentencing cannot be risk-free. A sentence can be formulated so as best to strike a proper balance, but it must be a balance. And there must come a time when a prisoner is entitled to be released. However, we have, alike with cognate provisions in the states and territories, the Crimes High Risk Offenders Act, which can provide for the extended detention of someone who has completed a sentence, or for their extended or continued supervision and at one time electronic monitoring for periods of up to 5 years after the expiration of their parole period. This, in effect, is a parliamentary endorsement of the proposition that some sentences are not long enough, or of the curious notion that judicial exercises of discretion in the imposition of sentences needs constantly to be revisited. The legislation proceeds upon the implicit basis that the state somehow has an obligation to guarantee the safety of all of us, and yet in practical and philosophical terms, this is nothing short of an absurdity. In the meantime, the currency of the prison sentence becomes ever more politically valuable. Before I conclude, I want to make it plain that I do not say that sentences should fail to reflect the criminality of the particular crime. There is a distinction to be drawn between the need for leniency and compassion on the one hand, and an inappropriate failure to give effect to sentencing principles on the other hand. Put another way, judges should never be afraid to sentence sternly if the facts demand it. And unless it be thought that I am not prepared to impose such a sentence when it is required, let me give you this example. In a case of the Queen and Abu Mahmoud, after a judge-alone trial, I sentenced the offender to a head sentence of 44 years for murder. Mr. Abu Mahmoud had cynically solicited the killing of a 15-year-old boy. He thought what he mistakenly believed was retribution for the death of his nephew in a street fight for which the assailant had been taken into custody on remand awaiting trial. The assailant was in that circumstance in jail and therefore beyond the reach of Mr. Mahmoud, who chose instead to order and pay for the killing of the assailant's younger brother. That boy, 15 years of age, was shot by a contract killer in his bedroom one night in Western Sydney as he slept. It's difficult to conceive of a more terrible crime by anyone who did not commit the act of killing. Even more tragically, in an awful twist, the brother of the deceased boy was later acquitted of the murder of Mr. Abu Mahmoud's nephew. Mr. Abu Mahmoud neither appealed against my judgment, finding him guilty of murder, nor the sentence I imposed for that crime. Finally, let me mention deterrence. It's also one of the Section 3A purposes of sentencing. What is deterrence? Deterrence in this context proceed upon the assumption or supposition that a person, rationally considering his or her options before committing a crime, will analyse the severity of punishments previously handed out to like offenders. This analysis, so it is said, will then play an important role in that person's decision whether or not to commit the crime, and before doing so, draw back and reflect upon what had happened to others who had been caught. So the argument runs, the drunken, violent husband who suspects his wife of infidelity researches sentencing statistics for murder or serious assaults before proceeding to attack her. The outlaw motorcycle gang sergeant at arms also thinks twice before stabbing his rival for the position because the jail time is going to be quite long. And the drunk in the pub chooses not to thump the person who knocked over his schooner because the consequences are just too scary. It'll be obvious that concepts such as general and specific deterrence in this context are not intended to reduce a sentence. On the contrary, the length of the sentence is thought to deter, and the longer the sentence, the greater the deterrence. The community and the media, stirred up by the papers, of course, love this stuff and accept it as holy writ. It has, as many of you will know, the endorsement of the highest court in this land. It is sufficient and respectful for me to say I do not share that view. Studies both here and overseas over many decades have consistently revealed, as you all know, that the singular most effective deterrent to all criminal activity is the likelihood of detection. Only when people who consider committing a crime appreciate that they're unlikely to go unnoticed, if they do, will they reconsider their position. And as practitioners in criminal courts, it's important to bear in mind when making sentencing submissions. Properly understood, not many cases qualify as vehicles for general deterrence, even accepting, as I do not, that general deterrence as a sentencing tool is effective. I would like to think magistrates and judges would be receptive to these arguments. Now, in expressing my views, I need to make it clear that as a judge of the court, I'm required to apply the law, and I have no difficulty doing so. I hold personal views that sentences are often, if not generally, too long, and that we overpenalise offenders in far too many cases. My views differ from others. They appear to differ from people in Victoria. For example, I can hardly imagine that a woman in her middle 50s sentenced to 3 life sentences with a non-parole period of 33 years for poisoning relatives with toxic mushrooms is likely to have her sentence changed by the Victorian full court, notwithstanding a Crown appeal against the inadequacy, so-called, of that sentence. But I've learned to expect that anything is possible. Lest anyone think that my views have affected my decision-making, I can tell you that, at least at today's date, in almost 19 years on the court, I have so far never had any sentence imposed by me overturned on appeal. Finally, I'm often asked if I find it stressful dealing with cases such as the ones I've described. My answer is always to say no, in the sense that I'm dealing with what are by then historical events. I would not like, by way of contrast, to be a police officer or a paramedical first responder who turns up to the crime scene when the awful circumstances are still raw. Thank you for your attention tonight. It's been a distinct privilege to address you in honour of the late Paul Byrne. May you all successfully aspire to the compassion and wisdom Paul brought to his practice of the criminal law. Thank you.
We here at Sydney Law School, as Justice Harrison has said he does, cherish the fact that minds differ. But personally, I have to say, I feel immensely reassured that a mind of such exacting reflexivity and penetrating insight and compassion and professional humility is in the head of the Chief Judge at Common Law of our Supreme Court. I feel reassured by the empathy that you show for the conditions of those incarcerated and the human impacts of your sentencing decisions. And I feel reassured by your willingness to engage in bold thought experiments such as that you put forward in the ANU conference paper that has caused you so much grief. So in contrast to the media narratives that you were alluding to, I personally feel much more secure after your lecture than before it. So I'd like to thank you, Justice Harrison, Your Honour, for sharing some of all that you have learned about sentencing and helping us understand the importance of it being approached with the greatest of care and with judicial courage, and also demonstrating that you do approach it in that way. So please join me in thanking our speaker.